Good morning, everyone. Just going to wait for you guys to tune in. While you all are tuning in, let me put my phone number. Hope everyone had a good weekend. Morning, Iron Baddies. How are you? Sorry, guys, I'm just trying to put on my stuff, my numbers in here. Okay, so 333-8751. Okay, there we go. Let me pen that. Good morning. Good morning, Iams Ramen. Good morning, Jumanji. Sexy Cher. Good morning. Simply Lenora. Good morning. What do you think of the fate of DACA? I think DACA's going to stay. I think DACA's going to stay because, there's definitely, bipartisan support for it. Now, are they going to create a path? I don't know. I don't know the arguments or the back and forths that they're going to go through. But I think DACA as it is going to stay. But again, my thought really doesn't matter. It's what actually happens that matters. So let's see. Good morning. If this is your first time tuning in, my name is Aisha Chidole. I'm an immigration lawyer here in Atlanta, Georgia, but I represent clients all over the United States with their immigration matters. We handle family-based immigration, humanitarian cases like VAWA, trafficking, U visas, victims of a serious crime, consular processing, family, fiance appeals, removals, detention, and all of that good stuff. If you'd like to schedule a consult, call us 407-995-6567 or 678-325-1037 or send a WhatsApp to 404-333-8751. It's pinned on Instagram. If you're on YouTube or Facebook, you can kind of see scrolling through the ticker. All right, let's get into your questions today. My husband got his green card, but I'm still scared. ICE is taking anybody with a pulse. Actually, ICE is not taking everybody with a pulse. I know that it might feel that way, but if your husband has his green card, your husband is fine. Hopefully, he doesn't have any criminal records. I don't know when he got. Oh, you said he just got his green card. So if he just got his green card, he should be fine. If there are criminal records, then that will be a problem, especially if they're happening post his green card. So as long as he stays out of trouble, he should be okay. All right. 87 mixed chick. Good morning, Keisha. Good morning. Grateful Mary. Good morning. My God bless lawyer. Thank you so much. Good morning. Good morning. Good morning, all. Thank you so much. You guys are so sweet this morning. Can VAWA still be approved if you were married but didn't put it in with the new spouse? No, it cannot. Or if it was approved, there will be a notice to revoke that approval. If your VAWA case, your I-360 case is pending, you cannot remarry. If you remarry, your VAWA case is not and cannot be approved. So they will either deny it or they will send you a notice to revoke an approval that happened accidentally. Basically, when you file for VAWA, it's fine to get divorced. It's fine if you're dating someone, if you're no longer with that person, you're separated, or it's fine if you have a child, but you can't remarry someone else. The minute you remarry, that changes your eligibility. Okay. I talk about this on almost every consult with me. And, I can't tell you how many times people start like a VAWA case and then they meet someone, they're like, oh, let me get married. I will have both people on both sides of the fence on my live, or maybe they're not on my live, but clients of mine who, followed the advice and waited, even though they were engaged, and waited until they made a decision on their case and then they got married, or they didn't listen and then they got married, with the hopes that you will not find yourself in the same situation that you found yourself in the first time. I will tell you guys that majority of people end up finding themselves in the same situation they found themselves in the first time. So, don't just rush into marriage. Don't just rush into marriage and screw any chances you have of potentially getting your green card because somehow you think I'm going to just marry this person and this process is going to go much quicker, not realizing that there's still good faith marriage, that you still have to prove with this person, and that you're still going to get a conditional green card, and you're still at this person's mercy should they choose not to file for you anymore or withdraw their application. Sean has asked, if I naturalize, does my 14-year-old get automatic citizen? Not quite. There are a few things that need to happen in order for your 14-year-old to get automatic citizenship. One, she needs to be a green card holder already. Two, she has to be in your care, like meaning you have to prove that she was with you or living with you. And then there are a few nuances which, change depending on what year the child was born or whatnot. That said, if your 14-year-old is eligible for citizenship, based on her being a green card holder and being in your care, you want to file an N-600, because it's always good to have proof of citizenship, that she's a citizen, because that's what gets people in trouble when they don't have that. So you want to do that. If you determine that she is. All right. Okay. What is the best way to file taxes without Social Security, ITIN, married filing separate or married filing jointly? I don't know. You're going to have to ask your tax accountant. I like to stay in my lane. I don't do taxes, so ask your accountant. Realist West, good morning. Asking for a friend, can Haitians still apply for adjustment of status for a green card? Yes, but again, there are some adjudicative holds and pauses, as you guys know, here in the United States. April 1st is coming. April 1st is that Thursday? I think it's Thursday, or maybe it's Wednesday. I'm actually not sure. But let me see what day it is. Yeah, it's Wednesday. So April 1st is coming. We'll see what happens on April 1st, where they are required to give instructions to USCIS officers of how to adjudicate these cases that they've put on pause. These are the 39 countries that they've put on pause here in the US. So, but otherwise, you should still keep applying. I mean, if you guys read the policy manual, you can see there where it tells you that they will continue to process your cases and continue to, go through the process, whether they need RFE or sending you to biometrics or need additional information. They're going to continue the process until they get to the decision point. Until they get to the decision point, then they have to wait until those instructions come on Wednesday. So let's see, what happens on Wednesday. And as soon as I find something, I'll give you guys breaking news. And so that's the answer to, I don't know what this other question is. I'm going to skip that. Are they approving I-765s for citizens of the 75 countries? Guys, remember that the 75 countries is not for the United States. The 75 country pause are for people outside the United States. Guys, please make sure you understand this. I talk about this on live every single time I come on live. The 75 country pause is for people outside the United States, not for people inside the United States. If you're inside the United States, and you're from the 75 countries, but you're also from the 39 countries with a pause, then no, they will not be approving your 765. But if you're not from one of those 39 countries, then yes, they will approve your 765. For instance, I can't remember all the countries off the top of my head. For instance, two countries that are in the 75 country hold, but are not in the 39 country hold, are like i.e. Jamaica, Ghana, for instance. Both of those, as I'm sure you can see from my timeline, they're getting the approvals and decisions made. And then some other countries are not. That said, one question people always ask me is that, what about for prima facie determination letter for people who file for VAWA? If you file for VAWA, you will get prima facie, even if you're from the 39 countries with a hold. Because remember, again, a prima facie is not an approval. It's kind of like a preliminary predetermination. Like, I even hate using the word pre-approval. It's like a predetermination that you've met the minimum elements to satisfy this case type. That said, when it gets to the decision time of approve, deny it. They're technically not supposed to make any decision. So hope that helps. Are there any special exceptions for an adult son who has an intellectual disability to get to stay in the U.S. while waiting? The answer will depend on how strong or viable your his medical condition is. You can certainly file for medical deferred action. We help people with medical deferred action all the time. Medical deferred action is basically where they allow you to stay here. Usually they give it in 2-year increments. And basically they will give you the 2-year deferred action and whoever the caretaker is. So let's say you, the parent, doesn't have status and you requested medical deferred action because you have a child, that this is what the condition is, or whatever it is, and the prognosis is not good if they were in their home country, or this is what the care is like in their home country. In that case, you can also apply for a work permit once you can prove your financial necessity to have one, if they give you. And then every 2 years, you can kind of renew your request for medical deferred action. So, again, it's on a case-by-case basis. So in those cases, they rely heavily on the medical doctor's diagnosis, need for care, need of how often they need to see the person, and all that stuff. So it will all really depend on that. I would say that for the most part, when we file for medical deferred action, majority of our cases generally relate to cancer, whether that's child cancer or adult cancer. But intellectual disability would depend on the country and how they've been coping and surviving in that country as an adult, because it's a harder argument to make if they've been outside of the country already for that long of a time as an adult. But again, it would depend on what new prognosis and stuff. It's truly case by case, to really see what evidence they have. Okay. Roger says, USCIS sent me a letter, annoyed, have all the evidence they asked, only our joint file taxes together. I'm not sure if you're asking me a question. So you can ask it. Sean is saying, what is the best number? It's right there in the ticker. You can see it on the bottom, 407-995-6567. All right. Or it's in my profile picture. Is Nigeria among 39 countries that are paused? Yes, Nigeria is amongst them. A person who got a 10-year green card through VAL, can I remarry and give my spouse that living in another country a status to come to the U.S.? Yes, you can. Okay, let's see what else we got here. Does being added to the lease as an occupant, is that okay? Do they need an SSN to be added as a joint leaseholder? Again, I can't answer that question. You have to ask your apartment complex or whoever you're renting from. Every office or every individual that's renting has different requirements. Some people, if they don't have a social security number or whatever, they may ask for a heavier, down payment or security deposit, to be there. Some people say no. So it's really up to your rental agency, depending on what or who you're renting from. The key thing also is that if you are not able to get on something because of your inability to prove residency, a social security number, an ITIN, document their rejection. That's my thing right now. And based on what I'm seeing, and I'm telling people, document the reason why you couldn't get it. Even those of you who have valid cases and say, my spouse was abusive, my spouse didn't want me to add this or didn't want me to be in this, document whatever steps that you've taken, or be able to articulate it in a way that makes logical sense. What steps you took to get those things and why you couldn't get it. Obviously, if you're a VAL applicant, there's absolutely no way you're going to have as much as generally. As someone who's in a loving marriage who wants to bring along his spouse or her spouse, obviously in the case of abuse, a lot of abusers love control and they basically pick and choose what they want to give you. So of course, there's an argument that could be made based on, control the power dynamics of a relationship where you have an abuser who has the upper hand and the other one. But whatever attempts that you've made to get or prove that you have a good faith marriage, we want to document that. Okay. And I'm not answering any more questions on the pause. If you didn't hear the first one, just play this back once we're done and you hear what I said. My F1 friend is being abused by her F1 boyfriend. She doesn't want him deported. Is there a way to have that on record, her injury, ECC, without getting him deported? I mean, if your friend is a student on a student visa and he's on a student visa, I mean, she can document it. She can document her injuries. She can go to a women's shelter. She should probably break up with that person as well. There's a possibility that she might even be eligible for a U visa based on abuse, depending on if it falls under a serious crime, since you're saying that there are injuries there. So if those injuries arise to the level of an aggravated felony, aggravated assault, those are things that could make her eligible for a U visa. Now, if she does a U visa, she does have to report to law enforcement, and which means that he could be arrested. So, it's a mixed bag. She has to make whichever decision she wants to, but yeah. What if you have a green card, but it's expired and you have to adjudication withholding? Can you still travel outside of the country with the temporary paperwork? So I'm not sure I understand your question, what you mean by to adjudication withholding. I truly don't understand what you mean by that. But if you have a green card, if you're asking if you're on the pause country, I'm not sure. I truly don't understand what you're asking me. This is for Winning Six Boss 6 Entertainment. I'm not sure I understand your question. But if you are if you have an expired green card and you're applying for an I-90 because you had a 10-year green card that's expired, you're exempt from the pause because you're legally required to have proof of residency. So you're exempt from the pause. So as long as you have that, right, you have that or your I-90, like your I-90 receipt, then you should be fine. Because your I-90 receipt should tell you that your green card is, extended for a period of time. What's the processing time for N400? The answer is going to depend on where your field office is. Most field offices right now, I would say we're seeing an average of about 6 to 9 months on average to be scheduled for an interview. What's the 765? That's a work permit. How long after biometrics for VAWA is a green card? Biometrics happens really early in your application process. So biometrics can literally happen within weeks of you submitting your application, whereas VAWA cases right now, they're taking like 3.5 to 4 years. So before I would say 3 to 4 years, but I feel like they're moving closer to 3.5 years. A lot of it also is because of the adjudicative holds and pauses. And what USCIS has started doing is that for certain cases, they're sending these new types of RFEs that are not very clear of what it is that they're looking for. So in the past, they would send you an RFE saying, okay, you submitted this document, we need this document, or we need more of this to prove that, whatever element it is. Now it's a checkbox. It's like a check mark. It's like, good faith marriage, check mark. And especially for cases that have really, really strong evidence. So that also causes delay because it's like, what do you want? Like, what is it that you want? We're going to send you these, and these. Or we're finding it almost feels like you move from like one officer to another officer. That person requested the RFE, and then you send it to another officer, and the person's asking for the same exact thing, not acknowledging that they received the other stuff. That doesn't happen often, but we're definitely seeing that happen as well. because they're moving it from one person to the other and they're asking for the same things when those things were sent. And so you kind of have to like push back and be like, what are you guys doing? You sent us this and we send this back, like make a decision. But biometrics from the VAWA green card is a very long time. What actually comes next is after the biometrics, if you're eligible for a work permit, is a work permit, and you've applied for one. Famzy says, I currently had my adjustment of status interview canceled in January, but still have my work employment process still in process. Is there a pause on this? Because I'm Nigerian. Yes, there is. Can a valid applicant with advanced parole travel abroad if they've overstayed? Technically, they could, but it will depend on each case. We never state, oh, you can travel without knowing your own personal immigration history. Even for clients of ours, every time they need to travel internationally, we request you must notify us so we can assess your case and assess the risk and state, is it worth you traveling or is it not worth you traveling? The idea of advanced parole, yes, is to allow you to travel, but you always want to assess the scenario. Has this person been arrested before? Has this person received an RFE? Have they had an interview that they're waiting on a decision? Have they gotten a notice of intent to deny? So there are just so many variables that we want to, first of all, check off before we say you can make an international trip. Because there's nothing worse than making an international trip and then they exercise their discretion and say, no, you're not coming back, or you're outside the country and you get denied. We actually had that happen to a client. They got denied while they were outside the country. And had it not been an error on USCIS's part, basically stating that they requested this person for an interview, but none of us got the documentation, we wouldn't have been able to get that client back in. Thankfully, miraculously, we're able to get that client in. We filed an appeal and contacted Congress right away and said, this person needs to get back in the country. And that was a situation where the client didn't notify us that they're outside the country. We just saw this denial letter and we're like, okay, let's see why. And then come to find out the person's out of the country. I was like, oh my gosh, but anyway, he's back and is a green card holder now, funny enough. And that happened in this administration too. Okay, let's see what else. No, I do not handle divorces. Sorry. If I petition for my unmarried child, but she had a child, how do you get the child to be a part of the filing with her? So in the I-130 part, she wouldn't be, but you can do it depends on when she had the child, right? But you can do like a follow to join, like as a derivative, when you're at the consulate level, depending on what level she had the child. And as long as the child, is still under the CSPA requirement under 21. Yeah. My DACA took over 4 months for the renewal to be completed and get the documents. Throughout the years I've had it, it took a week or so, but this time, so this is something to get used to. Yes, I will say that, guys. Honestly, like cases are taking longer to adjudicate. One of the things that one of the officers told me during one of my interviews with a client was that in the past, they could assess stuff quickly and make a decision, but basically their instructions right now are basically the level of heightened scrutiny, check, that they have to do. It's, even they themselves are second guessing themselves and really have to be really, 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 really thorough. And so that is, of course, causing cases to take a little longer than normal. to get approved, let alone if you're from one of the countries where, you know, you are, I was going to say, you're dealing with the heightened scrutiny that is about to happen. So it will take a bit of a longer time. And that's why it's really important that, because we know that they're using the scrutiny, that you really, really cover your bases and are very thorough in your application. You want to make sure that you have a legal professional, or a firm that is working on your case, that has seen hundreds of these cases, and knows what it is that USCIS is looking for, and knows what the red flags is, and knows what the issues are with people from your specific country. Because I can tell you, when you start working in the field of immigration, you start to see similarities in countries and the things that are needed or are missing or that cause denials. Like, I'll give you guys some simple examples from, let me just use 3 countries that we typically may use, or whatever it is. Like, for instance, of course, people with from in Nigeria that have Nigerian divorces, where the divorce happened in Nigeria, we already know that there's going to be a challenge potentially with a divorce. So we really have to thoroughly look at that divorce and make sure that that divorce meets the Nigerian registry standards, USCIS standards, before we submit that file. Because once we submit that file, and that divorce, it's hard to pull it back and amend and them accept that amendment, right? Another group of people will be like, i.e. Ghanaians, when it comes to their divorce, their traditional customary divorces with the red embossment and the affidavits. In those cases, that's an area where it's challenging. And again, we want to look at it thoroughly. And then when it comes to like Jamaicans, another group of people that we represent is going to be people who have common law marriages in Jamaica, where a common law marriage is really for property. You've lived with someone for 5 years and they do a common law marriage just because they want you to be able to get property if something happens, if you break up. But it's not a legal marriage, but sometimes they could refer to that person as their wife or their husband. And then when they're denying the case, saying, well, we're denying it because you said you had a husband and you never provided proof that you were divorced. And so we have to make the argument and say, no, that was not a legally valid marriage. That is a common law marriage, which USCIS doesn't recognize, and this is what the reciprocity said. So I say this to say it's really, really important that you're using someone that fundamentally understands the potential issues with that case type and can think ahead when they're reviewing your file to say this is going to be a problem, and help you or direct you of how to correct it before you submit it. Okay, guys. I actually have to jump off. I will talk to you guys tomorrow at 10 o'clock. If I didn't get to answering your questions, schedule a consultation for your own confidential consult. It's 407-995-6567. You can also send a WhatsApp to 404-333-8751. Our other number is 678-325-1037. You can call us on that number as well. I hope you guys have a great day, and I will talk to you guys later. Bye.